Referring to himself in third person, Arthur Collins tried to convince the judge to let him withdraw his guilty plea.
This pleading guilty was not done knowingly, intelligently, or wrong period.
Back in 2015, Collins pled guilty to second-degree murder, admitting that he shot George Joydoin several times in 2001. In asking that his plea be set aside, Collins said his defense lawyers at the time weren't working for him and refused to let him see the evidence against him.
I thought that he was working with the state to seal my conviction, and still they refused to withdraw or provide me with my discovery review.
Objecting to the motion, Associate Attorney General Jeff Strelzin noted that Collins confessed on 3 separate occasions and that there's no requirement that defense lawyers have to physically show their client the discovery.
I note that the defendant doesn't cite any case law that says that a defense attorney has to provide their client with actual physical paperwork.
Strelzin adding that it sounds like Collins wants to look at his file and has failed to cite anything that would suggest Collins is innocent.
Where 5.5 years after he entered a guilty plea, that certainly would have given him enough time to identify what evidence he claims is exculpatory that was not shared with him.
And Collins later told the judge he doesn't know of anything in the file that would prove his innocence.
The judge rejected Collins' motion in part, saying there was no evidence that the guilty plea was not made voluntarily or intelligently. However, he did say that if Collins has trouble getting his file, well, perhaps the court could assist with that. Reporting live, Ray Brewer, WMUR News 9.